Oh, hey guys. I meant to come back to this after I read Lively's opposition brief to Jed Wallace's motion to compel her deposition. There were some attachments, and I wanted to do them as a separate video because obviously the brief was quite long, and I forgot. And then we got Lively's response to Jed Wallace's appeal as well, so we went through that. But now I'm going to go through these documents. They're not too long. So we shouldn't be here forever. But we're just gonna start here. We got a bit of deposition. This is Blake Lively being deposed by Charles Babcock. This is obviously from last year. This is predominantly about the New York case, which, as you remember, Wallace had been dismissed, but Lively amended her complaint, brought him back in. So this is where we are at that point in time. Okay, so we're starting on page 246. Babcock then introduces himself. Miss Lively, my name is Chip Babcock. This is Joel Glover. We represent Jed Wallace and Street Relations, Inc. Lively says, okay. Nice to meet you across the table. Nice to meet you. Very pleasant and respectful so far. Lovely. Sorry about the circumstances, but it is what it is. I appreciate it. So Babcock says, I've just handed you Exhibit 1000, not 1001. It's just a notice of deposition. It's not a big deal. We just like to keep records. So you're here, and thank you for being here. Really love how respectful Chip Babcock is, actually. So, fantastic. Lively. Okay, do I need to take the time to read this? No. Okay. You can if you want, but there is just legal gobbledygook in there, so it's not a problem. Would you tell me what your definition is of personal knowledge? Hudson objects already. Lively says, knowledge that I retain myself in this context, without attorneys. Good. I was hoping you'd say that, because all of my questions are going to be asking you about your personal knowledge. Okay? And I don't want you to rely on your attorneys, something your attorneys may have told you, for reasons why there have been objections previously. Yeah. She can still object if she wants, okay? But she doesn't have to, because I'm not asking about that. So, effectively, Babcock saying, Hudson, I'm going to save you your breath here. Okay, so he starts out by asking, have you ever met Jed Wallace? I have not, no. Have you ever talked with him? Not to my knowledge, no. Okay, have you ever corresponded with him? Not to my knowledge, no. Do you know what he looks like? I don't. Most of us don't, actually. When I try to do my thumbnails, I have to use Babcock's image because I cannot find anything of Jed Wallace. Do you know what he looks like? I don't. Okay, you do know he lives in Texas. Objection. I do. Okay. You listed, I thought I heard, I may ask you questions you've already been asked, but I didn't catch everything down there. You listed everyone you thought had harassed you, and I don't think I heard Mr. Wallace's name. But the question is Mr. Wallace among the people that harassed you or not? Objection. I have never met Jed Wallace, so I do not think he participated in physical sexual harassment. Okay. And then Lively continues, I believe he was part of the retaliation campaign, and that was a result of that harassment. And then Babcock says, well, you done with your answer? Hudson then pipes up, sorry, I just want to, and then it jumps to another page. Babcock's in the middle of asking a question, so one specific author, which would be Mr. Wallace. And are you aware of any specific article that he authored himself, maybe in conjunction with others, but that he authored himself? Hudson objects. With his name on it? No, I understand Mr. Wallace's work to be quite clandestine, so I'm not aware of anything that has his name on it, no. How do you know his work was quite clandestine? God, she throws in these big words. Lively. That's how it's been described to me by everyone who knows him. that, yeah, that everyone who I've spoken to who knows him, it's also what was described in the documents we received, both in the Jones Works documents as well as documents in Discovery. I mean, how many people does she know who know Jed Wallace? I would have thought they danced in different circles. Oh, I think it looks like Charles Babcock is also about to ask the same thing. Who described him to you as quite clandestine? You said that people told you that. Who told you that? Lively, I don't know that those were the words that we used. Sure. That was the general sort of descriptor or the general idea. Hudson. And you're excluding counsel? Babcock, always. And then Lively continues. I was told by Stephanie Jones. Oh, interesting. I was told by Stephanie Jones about his and the nature of the way he works and how he works. So, Stephanie Jones, how the fuck does Stephanie Jones know Jed Wallace? Like, does she know him? Does she have actual knowledge? Has she just heard about him and therefore it's just Chinese whispers? I mean, I would like to know a little bit more detail about that, but so the sum total of all the people that she's spoken to, because this is now a very different statement to what she originally said. She made it sound like there was loads of people she'd spoken to who knew him and described him as clandestine. Now we boiled it down to it's just Stephanie Jones. There are, well, outside of attorneys, yeah, he has that reputation. Yeah, a lot of what I know of that is through attorneys. How do the attorneys know Jed Wallace? But I also in the messages, I don't remember if it was Jennifer Abel or Melissa Nathan who described his work as untraceable. And there were other messages which I think Babcock kind of cuts her off and said, okay, so the three names of people who might have described him as quite clandestine would be Stephanie Jones, Melissa Nathan, and Jennifer Abel. Would that be correct? And then Lively says, well, there were others. I don't remember if it was Katie Case or Brianna Coslow, who also described his work in the documents that we've. And then Babcock cuts her off again and says, does Coslow also go by Butler? Hudson objects. I don't know. Okay. In any event, are Miss Case and Coslow, are they part of the conspiracy against? And then it cuts off, goes to page 277. Lively looks like she's in the middle of an answer. Don't remember specifically who else was there. It was a very emotional and upsetting day. It was hard for me and Isabella to continue our work. We kept breaking because we were incredibly distraught. I'm dying to know what she's talking about there. Okay, and then Babcock continues. And the statements by the Sony people that you identified were in person in Copenhagen. Is that right? Yes. Okay. There were also, and she continues, there were also Sony representatives in New York and in California and internationally. And my publicist, Leslie Sohn, I believe to be in New York at the time that she called to let me know of the negativity and of the hiring of Melissa Nathan. Attorney Babcock. Okay, object as non-responsive. On December 20th of 2024, you filed a complaint with the Civil Rights Division of the California agency in charge of the Fair Employment and Housing Act, correct? Objection. I'd have to read the document to know. Sure, I'm going to show it to you. Then he goes, here you go, let me hand you Exhibit 1048. There you go. 1048 is a 3-page document that lists Jed Wallace and street relations as two of a number of respondents to your complaint of employment discrimination before the state of California, correct? Jed Wallace's name is listed amongst the defendants, yes. And what was the second part of your question? I'm sorry. Street Relations Inc. was also listed, correct? As a respondent? Yes. All right. And this complaint was verified by your outstanding lawyer, Ezra Hudson, who is sitting next to you, I think. Is that right? Hudson objects. And then Babcock says, I would object if I were you. And he continues, it's on the last page, I think. Lively says, yes. And she was your lawyer with respect to this complaint, yes? Correct? Lively says, yes. and the complaint indicates that there is an attachment that says, please see attached complaint for specific details. Do you remember that? Do you remember that it had an attachment? My initial complaint? Yes. Yes. Okay. Babcock then says, let me hand you 1049. And is that the attachment? Lively says, well, I'm unable to read all of the pages right now, so if I'm going to have to go on trust to know if it's the attachment. So I don't know, but Babcock says, does that kind of look like what the attachment was? Hudson objects. Lively, it kind of looks like what the attachment was. Babcock says, okay, if it turns out not to be, then it's going to be on me, not you. How about that? Is that fair? Lively, let's hope so. And then Babcock asks, and then that same day, one of your lawyers, Mr. Gottlieb, sent a letter to a number of the people who are now defendants here, correct? Hudson objects. Babcock, do you have those Gottlieb letters? I believe it's going to be 1043 through 1045. Actually, one letter with some attachments. Maybe I got the wrong number. It's this one. Babcock, let me hand you what's been marked as 1042. Sorry, I stated the wrong number. Have you ever seen this exhibit before? It's sent on behalf of not only Mr. Gottlieb, but Miss Hudson as well. Lively says, I need to take a minute to look at it to know if it looks familiar, and that's where the deposition ends. What is missing from those deposition papers? So I do not know if the questions were asked and I think this is what Babcock wants this extra deposition for, is, Miss Lively, how long did the New York Times have a copy of your draft CRD complaint? How long were you working with the New York Times? Why did you put this in the New York Times? Why did the New York Times imply to the world that Mr. Wallace was being sued for sexual harassment? Why did they not make it more clear? Was that your direction, or was that something that you gave the journalist license, to kind of craft? It will be those kind of questions that try and get to the malice of, you put all this in the New York Times. How long had you been working on this? And why was Mr. Wallace portrayed in the manner that he was? In a very misleading manner. Because there's nothing in here about what happened after the CRD was filed and the whole New York Times of it. And I can't believe she wasn't asked. But we've got to remember was Chip Babcock only had 1 hour with Blake Lively. Probably had a fair amount to get through as well. I don't know if he got to it, and if he did, it is not in amongst these pages here. If he didn't get into that as much as he wanted to, then I can see that being the reason why he wanted to ask her more questions. Plus, he may want to know a little bit more about why she's applying 47.1 to him specifically, and how have you racked up, nearly $1 million of fees just defending this, but we didn't even get to discovery. So there'll be multiple things there. I think that's my opinion. I could be wrong. Okay, so this is the email trail. I'm going to go down to the bottom because it actually starts from the bottom. So it's from Chip Babcock, July 13th, 2026. Dear Michael, I enclose the attached pleading notice for your client for a deposition on August 4th, 2026 at 10 a.m. in New York City at Lankler, Cipher, and Wall. Given the delay in scheduling this deposition while we discuss settlement, my client will adjust the date, time, or location for the convenience of the witness or you. Make that a bit bigger. But only if there is an agreed upon firm date, time, and location acceptable to my client, and there will be no effort by your client to quash or seek protection from the deposition at any time. It sounds like they've talked about it. It sounds like they were talking about it during the settlement discussions. Okay. The remainder of this email relates to our ongoing settlement discussions. So they're having settlement discussions too, which must be finalised by August 4th, 2026, or my client will end negotiations and take his chances in court, as will yours. So there was settlement discussions between Wallace and Lively. I mean, they have to really, but okay. So this is from Babcock in response. This is from Gottlieb in response. Chip. The purported notice of deposition you emailed earlier this week without leave of court has no legal basis. As you know, the Wallace party's complaint was dismissed in its entirety for lack of jurisdiction on November 12, 2025. And final judgment was entered on April 13th, 2026. Thus, you had no authority to send Ms. Lively a notice of deposition under Rule 30, as courts do not grant discovery based on a complaint that has already been dismissed. If you are aware of any contrary authority, please feel free to provide it. Although I would recommend you consult the position that you and Joel advanced on behalf of the Wallace parties when Judge Lyman dismissed Ms. Lively's claims against your clients on July 16, 2025. There, with leave to amend, you argued then that your clients were no longer parties for the purposes of Miss Lively's deposition, which had been noticed for July 17th, and would only consider themselves bound by Rule 30 with respect to that deposition if Miss Lively amended her complaint that day to make the Wallace party subject to a live pleading. The difference here now, right, just to point this out, is yes, Lively, he's saying, well, your clients weren't prepared to sit for a deposition because they were no longer active parties. In Lively's case against Wayfarer and Wallace, and that the only way they were going to sit for a deposition was if Lively brought them back, which she did. The difference with this case here, which I think Gottlieb's missing, is yes, the case has been dismissed. Lively is technically no longer a party, fine, but she is still seeking something from the court, i.e. her fee motion. So she is still actively participating, even though she is no longer a party. Okay, so the case has come to a conclusion, like it has for the Wayfarer parties against Lively, but there is still outstanding things to be done. There are still motions being filed and briefed, and the same thing is happening here. So I think this point, your clients said to us when they were dismissed that they wouldn't sit for a deposition, but Wallace did not seek attorney's fees and costs and everything else from Lively once he was dismissed. In theory, there's no reason, nothing stopping him. He could, but he didn't. There's no indication that he intends to. But Lively has filed for that, and she's asking for it under a new law. It's only had a ruling on once, and that is in the completely related case. So I can understand why Babcock's like, well, hold on a minute. Judge Lyman has set these new standards. It's raising questions now on whether we want some very limited discovery to prove that we met those standards, or prove malice in this case with Lively. That's what's going on. It's very different. So it's not, well, your client said they wouldn't sit for a deposition after they were dismissed, so now our client's not going to do it. It's not the same thing. Gottlieb's an idiot. Yeah. Where am I now? Your clients were no longer parties for purposes of Miss Lively's deposition, which had been noticed for July 17th, and would only consider themselves bound by Rule 30 with respect to that deposition if Miss Lively amended her complaint that day to make the Wallace party subject to a live pleading. Following the same arguments you made in the SDNY action, as well as every case we have found, your post-judgment notice of deposition is null and void. Yeah, he's talking. I'm not happy with what he's saying. There is still unfinished business, and that is because of Lively. To the extent you are hoping to take Miss Lively's deposition based on your own interpretation of Judge Lyman's order granting Miss Lively relief under California Civil Code Section 47.1, I have already explained to you why your interpretation of Judge Lyman's order does not make sense as applied to the posture of this case. In any event, your personal musings about the possible implications of Judge Lyman's order do not arm you with unilateral legal authority to issue deposition notices in litigation that was dismissed with prejudice. I thought it was dismissed without prejudice, so that he could have taken it somewhere else if he wanted to. I'll have to check that. That's true regardless of whether you are purporting to rely on Rule 30 as explained above or Rule 54D, which does not permit discovery except by leave of court, which you did not seek and did not have when you sent this purported notice. Nor would you obtain leave if you sought it. Miss Lively's fee motion is fully briefed, and the Wallace parties waived their right to seek discovery when they elected, fully advised by able counsel, to oppose Miss Lively's Rule 54D application on the existing record without seeking additional discovery, just like the wayfarer parties in the SDNY action. You appear to be taking the position that you did not understand until reading Judge Lyman's order that discovery might be necessary to satisfy your burden under Section 47.1. But Miss Lively fully briefed and discussed your burden in her fee motion, and the Wallace parties elected, notwithstanding those arguments, not to request discovery and to submit briefing on the existing record. For present purposes, you and your clients are on notice that should you pursue this frivolous discovery, Miss Lively will continue to be represented by all of the attorneys you are communicating with here, and all of the fees and costs that go into opposing your discovery will be added to the fee total we will submit to the court. Yeah, so he did try to throw there are a lot of us and we all charge a lot per hour, which is shitty of him. I know you have reviewed Miss Lively's fee motion in SDNY, so your clients are also on notice about the hourly rates charged by Miss Lively's attorneys. Should you elect to proceed down this path, the Wallace parties will have no argument that they were unaware of the potential costs of doing so. Furthermore, should you seek leave of the court to take a belated second deposition of Miss Lively, we'll remind the court that you already had one bite at this apple. Along with opposing your request, we will request, in the alternative to our position, leave of court to serve discovery to ensure that any record beyond the pleadings is not artificially and improperly one-sided. This will include document discovery on your clients for the many, many documents we know were not produced during discovery in the SDNY action, including those we learned of before, during, and after his deposition, and we will also seek the depositions of your clients, along with depositions of at least Melissa Nathan, Rosa Kalantari, Brian Friedman, Katie Case, and Jamie Heath. Why? This is literally about the fee. It's nothing more than that. Why would you take all of their depositions? You can't just go... Now he's being a cunt. Oh, well, we're going to inflate our costs by all this, by doing all this additional discovery. That's just being a knob, and it's discovery they don't need. They've already been dismissed. It's a limited bit of discovery that Wallace is asking because of the application of 47.1. New York, the decision in New York by Lyman on Rule 47.1 is not binding on Texas. So Wallace still has an argument to make that it does not apply here in Texas. That's why he wants limited discovery. Lively is just threatening to do it to be an asshole. Like, well, if you're going to make things difficult for us, we're really going to come in and make things difficult for you. It just seems like a right twat. As for your settlement correspondence, I'll address that by separate email. I'm sure you did not intend to link your threat to take discovery with zero legal authority with a settlement demand. What threat? Okay, so we're now on July 29th. Dear Michael, in light of the below, I assume that Ms. Lively will not appear for her notice deposition on August 4th, 2026, next week in New York, so that I do not incur unnecessary travel expenses. Would you please confirm that today, or in any event not later than Friday? Thank you in advance for this courtesy. Best, Chip. I would not be being kind to Michael Gottlieb after that. So Gottlieb responds, Chip, I explained this in my July 17th email. The notice you sent is not a valid deposition notice. It was and remains powerless to compel anyone's appearance anywhere. Would your client show up if we emailed you a similar notice? Of course not. I expect you know this, because in the 12 days since I sent the email below, neither you nor your very capable colleagues have been able to come up with a theory, let alone a citation to a case, rule, or statute that would provide any basis for sending a deposition notice without leave of court in a case in this posture. Of course, if you'd like to send us any citations providing legal authority for taking discovery in this matter at this point, we'd certainly be happy to consider them in evaluating your position. Respectfully, Mike. Babcock then, 29th, so still the 29th. Michael, I did not mean to suggest that in the 12 days she had to think about this and that your client had changed her mind, but as an optimist, I always have hope. Thank you for your courtesy in promptly confirming that Miss Lively does not intend to appear at deposition. As for authority, my very capable colleagues did not come up with anything I have not already told you, which is we rely on the pendency of your post-dismissal motion. The issue of malice in light of Judge Blyman's ruling, prompted by Miss Lively's legal position in the SDNY and in this case, and Federal Rule of Civil Procedure 54. I know you and your very capable colleagues have evaluated our rights and Miss Lively's responsibilities in light of those authorities. And then finally, from Gottlieb then, still on the 29th of July. Chip, given your written concession that you are relying upon Rule 54, which does not authorise discovery absent leave of court, your statement that Miss Lively does not intend to appear at a deposition is a material, factual misrepresentation. Miss Lively appeared at her deposition. You were there, and you conducted an examination. There is no further deposition for her to appear at unless and until you obtain permission from the court to conduct discovery in this dismissed action. And as the advisory committee notes to Rule 54 make clear, it is rare for the court to determine that discovery would be appropriate. You are advised not to repeat the above misrepresentation, whether to the court, the press, or any third party. We reserve all rights should you choose to do so. That's rather threatening. It really is a prick, isn't he, Michael Gottlieb? Okay, so now we're going to pop on to very brief affidavits. There's nothing much here. So this is Laura Prather, the Miss Lively's Texas attorney. Pursuant to blah blah blah, my name is Laura Lee Prather. I'm over 21 years of age, fully competent to testify about matters contained herein. I'm a partner at this place and I represent this dickhead. The following statements are made within my personal knowledge and are true and correct. I submit this declaration in support of Miss Lively's opposition to plaintiff's motion for discovery. On October 23, 2025, this court ordered the parties to the above captioned action to submit a proposed scheduling order within 30 days. On October 11, 2025, counsel for parties met and conferred regarding a proposed schedule pursuant to Federal Rule of Civil Procedure 26F. I hereby declare under penalty of perjury under the laws of the United States of America that the above is true and correct. Okay. That was helpful. Now we have Michael Gottlieb's. Oh, this is tiny. Pursuant to this, Michael Gottlieb declares, my name is Michael J. Gottlieb. I'm over 21 years of age, a lot over 21 years, and I am fully competent to testify about the matters contained herein. I'm a partner at this place and represent the same dickhead. The following statements are made within my personal knowledge and are true and correct. I submit this declaration in support of Lively's opposition to plaintiff's motion for discovery. Attached as Exhibit A is a true and correct copy of certain excerpts of the transcript of the deposition of Blake Lively taken on July 31st, 2025. Attached as Exhibit B is a true and correct copy of an email exchange with counsel for plaintiffs regarding their purported notice of deposition directing Miss Lively to appear for a deposition on August 4th, 2026. I hereby declare under penalty of perjury under the laws of the United States of America that the above is true and correct. Ugh. Something about Michael Gottlieb that makes me nauseous. Right, okay, so those are the attached. They were actually attached by Lively. I'm astounded that Gottlieb thought it was a good move to attach that email thread, because it does make him sound like a jackass of the highest order. Even if he has a point about, Rule 30 and Rule 54D, and whether the notice is valid or not, the threats that were in there were astonishing. So Jed Wallace is due to reply. I can't remember the date. I will put it in the comments, pin it to the comments, so I'll have it when I look it up. But yeah, sorry this was late coming. I completely forgot. And I will still get to the Sarowitz case against Celeste Smith.